Hi, everyone. Today's episode is the final episode in the case of Penelope McGee. She is being tried by the Commonwealth of Massachusetts for the alleged manslaughter of her ex-husband, Andrew Savitz, back in February of 2020. So, stay tuned to the end because the way this ends is really not what I predicted. So stay tuned. Hi, everybody. Welcome back to the channel. Hey, don't forget, thumbs up. Woohoo. Yes. If you enjoy the content, and consider subscribing. If you're already subscribed, consider becoming a member, or you can make a one-time donation. Down there it should say you can make a donation. I forget where it is. There's a little button. Anyway, but more importantly, you want to hit the notification bell, especially all, so you don't miss a single episode. But you also want to check your phone to make sure you're allowing notifications from YouTube, because I hear from everybody, I missed it. Yeah, I know. So interesting day in the courtroom. So yesterday I told you the state rested their case against Penelope McGee. Now, Penelope is being tried for the alleged manslaughter, which is an unintentional murder of her husband, ex-husband, Andrew Savitz. So, not a lot of witnesses. Two really main witnesses, which would be the medical examiner and her daughter, Zazie Savitz. Zazie Savitz. That's the coolest name, by the way. Just coolest. So again, the defense does not call any witnesses. Nope. Defense rests. She did not take the stand in her own defense. She didn't need to. I told you she didn't need to. She really didn't. Because those two witnesses weren't particularly strong. Zazie had a grudge against her mom. For what? I have no idea, but not liking mom. So a reason to question her credibility. Now, this is a bench trial. There is no jury. They're making their arguments in front of the judge. And this is the same judge who is presiding over the Karen Reed case. Karen Reed was tried for alleged murder of her husband and got a hung jury. So she's waiting on a new trial in front of the same judge. So interesting. I think I remember this from another case. When they do their closings, the defense goes first, then the prosecution. There was another case that happened. I forget the name of the case, but in any case, usually we see the prosecution splits their arguments. They make an argument, then the defense, and then they make another argument. The prosecution does. Not here. So the defense kind of has to anticipate what arguments are going to be made by the prosecution when they're giving their closing arguments, so they can leave no stone unturned here. So this gentleman started out by, and he's a very good lawyer, by the way, started out by arguing that like I said, two key witnesses, the daughter, the medical examiner. So start with the medical examiner. He said it's absurd and an unlikely proposition that she put forward that, but for the actions of his client, Penelope, he would not have died. Yeah. So the prosecution, and I might be combining the closing arguments here because he anticipated what they were going to argue, and they certainly did argue that she went to that house based on some email about the eviction and she was angry. Well, he said she went to that house that night because she lived there. She was living there. He offered to let her live there following the eviction that was finalized 2 weeks before this event. So that's why she was there. They were on the couch. They got into a discussion about the eviction, and then things escalated from there. But she wasn't angry when she got there. She had a relationship with the guy. She waited till after Zazie went to bed, which was their arrangement, because he had asked for her not to have anything to do with their daughter. She didn't want anything to do with mom. And they went into the living room, sat on the sofa, were having a conversation, and it escalated. So then we have Zazie Savitz. He talked about, he says, clearly she's biased. She gave many different versions of what occurred that night. She gave a version to the police at the scene. She, 3 hours after her father died, she was interviewed. She gave another version. So this is like early the next morning. Then in August of 2024, she gives another version. And then in January 2022, she gives yet another version. And then he said, when she testified here, again, we have a different version. And he didn't specify, what was changed about all the versions. And he says, I'm not really saying that I'm not saying she's a liar or that she's a bad person, but she just, your memory changes over time. It's kind of a known fact that people can influence your memory of a situation. The best memory you have is one you give right after. The one she probably gave it to the police at the scene or the next morning. But after a while, other people can influence your memory, and then you just kind of adopt that as part of your memory. I hope that makes sense. But in any case, she was inconsistent on multiple occasions. Then he talked about how the prosecutor, and he says, I'm not criticizing the prosecutor, but they were misled by this medical examiner. And then he talked about how this medical examiner is less than credible based on something happened during that Karen Reed case where she's got additional evidence and she changed her story or she changed her findings. I don't know. I didn't cover that story. I want to get into it before the new trial starts and figure out what happened, because same medical examiner. But, he said the question is, who's responsible for the conduct? This precipitating event. And he did get her to admit that it could have been him. He can control his own anger, and who would have known about his medical condition better than he would? And that it's just as likely that it could have been his anger that precipitated the event versus her anger. Then he talked about the injuries. The medical examiner, didn't know how or when these happened. And despite that, she said none of those would have caused his death. And we heard from the paramedic that some of those could have been caused from CPR. So one of the things the state pointed out is that there's two ways. She's been charged with involuntary manslaughter, and there's two ways you can find a conviction for that. The first is the unlawful killing, which is unintentional by reckless conduct. The second one is unlawful killing, unintentional by battery, that the defendant knew or should have known created a high degree of likelihood that substantial harm would result. So he's saying, the defense attorney is saying, what was the unlawfulness? They were having an argument, a verbal altercation. There was some pushing and shoving. It proceeds into the kitchen. He pushes her into her refrigerator. I guess at one point during the trial, the prosecution showed a picture of this refrigerator, which had pictures and stuff hanging from it, which were not disturbed by something maybe having been backed or shoved into a refrigerator. And he says, maybe it wasn't the refrigerator. Maybe it was the stove that was right next to it. But in any case, it knocked a ceramic bowl off of something that fell and hit the floor and shattered. But is any of that unlawful? I mean, yeah. I don't know what's the criminal conduct, that she slapped him once, that she pushed him once or twice, maybe even 3 times. Is that unlawful? That she shoved him? They were having this altercation. between the two of them. And they always say the truth lies somewhere in between. I suspect he was going at her and she was going at him. And then he talked about how the medical examiner completely ignored her self-defense statement that she gave at the scene to a police officer. And they had asked her to step into another room. Well, she stepped into another room. Everybody's doing CPR. She steps into another room and they're asking her what happened. Meanwhile, 15 feet away, she can still see what's going on with her ex-husband. There's yelling and, CPR going on. And, but she gives this statement of self-defense, which, like I said, memory's best right after the event. But the medical examiner never took that into account. So he said not to mention everything else, but to convict this woman would be a real slippery slope here. It's the same thing that I talked about yesterday. Where does it end? Can I be on the phone and I upset somebody and they have a heart attack and now I'm responsible because I said something to upset them, and I knew that they had a condition, and I knew that would result in substantial likelihood of harm? No. So he was, of course, questioning the Emmy's credibility. I told you about the Karen Reed case. Then he talked about the thousands of pages of medical records that they got, because he had an accident back in August of 2019, and then 6 days before this event, he had another accident, totaled the car both times, both major car accidents. And the medical records don't reflect anything more than he was told to watch your diet and exercise. There was no restrictions on his activity, nothing like that. But then we hear from the prosecution during their closing arguments that, in fact, they had identified some problems cardiac-wise and advised him to follow up in 4 to 6 weeks with a vascular surgeon. But there were no restrictions on him. And did we know if she knew that? She did know that because she told that to his brother in an email, that his left ascending artery or something like that, was clogged and he might need vascular surgery in the future. Not urgent, she told her brother. Not urgent. Okay. Then he anticipated that, before we leave that subject, he read to the judge. I found this fascinating. In August of 2019, after his accident, they figured he had a stroke, but in connection with that stroke, they did a cardiac workup. And here is the results. He read the results of this thing, and I was kind of flabbergasted.
Where there was a cardiological workup, and it was in relationship to the cerebral vascular workup that they were following Mr. Savitz on August 20th of 2019. And in the context of reviewing his physical condition, Newton Wellesley conducted this cardiology examination of his heart, a detailed examination. And what are the result findings is found on page 11 and go into page 12? That his left ventricle wall thickness and cavity size appeared grossly normal. His left ventricular systolic function is normal. His right ventricular size is normal. His right ventricular systolic function is normal. His left atrium is normal. His right atrium is normal. His mitral valve has no evidence of stenosis, as described. We got the definition of stenosis from Dr. Dietrich. His tricuspid valve appears normal. His aortic valve, there's some thickening. There's no evidence of valvular aortic stenosis. There is no evidence of pericardial effusion, fluid around the heart, as the ER doctor testified to, that he saw no such evidence when he examined Mr. Savitz on January 29th of 2020. I could go through pages and pages of these 1,500 pages, and I submitted a list, and I understand as a trier of fact, the court has had occasion to look at it. There is nothing in these records that show there was any concern by multiple doctors in different situations where they did routine as well as exacting and specific examinations of Mr. Savitz's heart and saw nothing truly abnormal, and that his heartbeat was normal. No evidence of heart murmur. The reason this is so important is because it goes directly to the level of knowledge and the quality of knowledge of Ms. McGee.
Normal? Everything's normal? I don't know what kind of testing resulted in them showing that everything was normal, but obviously on the internal examination at death, everything was not normal. So then he talked about the 911 call. And that 911 call, I couldn't make heads nor tails of it. But according to the defense attorney, he says Zazie Savitz is the one saying, stop, stop. No, that you couldn't make out. Somebody kept saying, stop it, stop it. Well, apparently she was saying, Dad, stop it, stop it. And then at one point she said, you guys stop. Because back to what I was saying, was probably both of them. So then the state puts on their case, and she reiterated, but for the actions of this defendant, he would not have died that day. The medical examiner said it. You heard it, you know. Then she went over involuntary manslaughter, which you would want to do if you were in front of a jury. But they're in front of a judge. The judge knows the standards for involuntary manslaughter. You don't need to go over all that. Then she goes through causation, and she kept saying cartoid instead of carotid. Now, I get it. She's a lawyer. She's not a medical person. I happen to be a medical lawyer, registered nurse, and an attorney. So it's not a mistake I would have made 4 or 5 times during her argument. But to me, it felt like if she had been more prepared for this case, she would have had more discussions with that medical examiner, and she would have been ultimately or intimately familiar with carotid, because they would have had a long discussion about the carotid. No, it's the carotid artery. So it reminded me of that trial, the other trial I covered back in December. I felt it left me with the feeling that, is this a case she got stuck with? Because it didn't, she gave a very short closing, less than 20 minutes. And that happens at a prosecutor's office. Somebody will file the charges and then someone else gets the case. And you're like, oh, great. I got this. You gave me this one. Thanks. But you got to follow through with it, So I talked about that email. She said that if you're going to claim self-defense, you have a duty to retreat. She never retreated. If she's claiming that, he's pushing and shoving her in the kitchen and trying to get her out the door, shoving it, why doesn't she just leave? Just leave. And she didn't. So those were the closing arguments. She said, that gives you enough, Judge, to find her guilty. But for her actions, he would not have died. So here's the interesting part. The judge, as soon as those closing arguments were over, she said, I've reviewed everything. I don't need to take a recess. I've made my decision. I'm like, because I told you guys yesterday, some of these judges will take a long time. I had one judge take 3 weeks to render a decision on a bench trial. Nope, I've made up my mind. Here is the verdict.
On manslaughter regarding on the theory of wanton arrest, reckless conduct, I find you not guilty, and manslaughter caused by a battery, I find you not guilty. So,
Ms. McGee, your discharge was held in the process. There being no other process, you're hereby discharged. Thank you.
thank you.
Now, did you notice she's hugging all those people? Did you notice none of her 3 children were there? None. And they're all adults now. Well, I don't know if the youngest is an adult, but the older 2 are adults. Nope. None of those 3 are supporting her, which is sad, really sad. But I was also wondering, I said all along, this is not really, criminal was not where this should have been. It really should have been like a wrongful death lawsuit brought on behalf of the kids. Because now they're without their mom or without their dad. And it may be, they may still be having, in fact, I'm going to check. Hold on. I could not find anything, but if there was a wrongful death, that would probably be successful against her because of the eggshell theory. You take your victim as you find them. And if it went to a jury, I can imagine that the jury would be swayed by sympathy, and then the standard's different. It's not beyond a reasonable doubt. Is it more likely than not that her actions resulted in his death? In this case, it was beyond a reasonable doubt. And since we had the medical examiner saying but for, and then later on admitting on cross-examination that it could have been his own actions, his getting angry, that caused his own death, you got 2 different versions. Then you got to have reasonable doubt there, and the judge did, obviously. So let me know what you guys think in the comments. I love to read what you think, and I will see you guys in the next video. Have a great day, everybody. Take care. Bye.